Can we just kind of talk about Cowichan tribe versus Canada? What has happened over the last few months? Obviously, this has been quite a long court decision, I guess, to summarize it. But can you just give us high level what's going on and we can discuss it from there?
Sure. There is a lot, so I'll try to be very brief. The claim was originally filed in 2014. The trial ended in 2023. So 9 years later, 513 days of trial time. I believe now they say it's the longest civil trial in Canadian history. And then almost 2 years to get the reasons from the court. So the claim, ultimately, at the end of the day, was for approximately 1,800 acres of land in the city of Richmond, a declaration of Aboriginal title on those lands. Aboriginal title is a right to the land. It's the Aboriginal right to land. It's not an interest in land. We'll talk about that maybe a bit later. Yeah. It's a right to the land. And then at one point, before I get to the decision, this is important, I think.
Yeah.
At one point, some folks came forward and said, hey, shouldn't we give notice to the other folks within the 1,800 acres that aren't named? So you have Canada, BC named the Airport Authority, Powassan, Musqueam, and the city of Richmond. And the court decided, no, we don't need to give notice to the other landowners, and those owners include businesses, some large, some small, and private homeowners. We don't need to do that because the decision won't affect them. Okay, so remember that. We're going to come back to that in a few minutes. So fast forward to August of this year, and the reasons come out. And the judge found that there is Aboriginal title on 800 of the 1,800 acres. So you've got now black line around 800 acres. The judge said, I'll give 18 months before my decision takes effect. And in the meantime, British Columbia, you need to go negotiate with the Cowichan to sort out all these other private landowners that were part of the litigation, but whose land now is encumbered, as the judge put it, with Aboriginal title. The judge said that the Land Title Act on the 800 acres doesn't apply. Think about it. If you own land right now, you rely on the Land Title Act, and specifically it's Section 23 and 25. The whole Land Title Act's important, but as a lawyer, I like the whole act, but It's 23 and 25, and what those sections basically say is, see this title? This means something against the whole world, including the government, that you own this land. What the judge says in the decision is that on the 800 acres and off the 800 acres, the Land Title Act doesn't apply. But she doesn't invalidate the title, interestingly. So she says, you get to keep your title. I'm just going to, this is how I describe it, I'm just going to erase everything on the page. Because the guts of the title, like what makes the paper valuable, is the Land Title Act. The judge, interestingly, also says that the decision doesn't affect private parties until the Cowichan or another First Nation goes to obtain the land and take possession of the land. I say with the greatest of respect to the court that I believe that's incorrect on its face. That in fact, those folks on the 800 acres were affected immediately upon the release of the decision from the court that said, all that land that's held privately can't rely on the Land Title Act anymore. One other comment I'll make. The judge says, look, when the Cowichan decide if they want to go to court at some point and they want to obtain that land, the private landowners can defend it and they'll have their title. But remember what I told you earlier. So what's the first defense fee? You don't have to be a lawyer to figure this out. You're going to reach for your title and go, oh, judge, they're not entitled to my land because I got this certificate of title from the government of BC that says I'm indefeasibly entitled to this land. And the court will go, yeah, but the guts of your title have been erased because you can't rely on the Land Title Act. So all you're left with is a piece of paper that is evidence that you once had indefeasible title. That is not an exaggeration. I will just say it is not hyperbole. I am not trying to fearmonger on your show. That is what the judge and the decision said. It's not open for argument. In fact, the court was quite articulate on this point. Final point I'll make. Remember I said the 800 acres?
Yeah.
The judge, interestingly, also said, oh, by the way, a precedent that's going to flow from my decision is that my analysis of the effects of title on private land, the fact that they can coexist according to the judge, applies throughout all of BC. Now, I didn't say that. I'm telling you that's what the court said. I got the paragraphs here somewhere, right here, in 6 different places. Now, why do I stress that to you as a final comment? There's a lot of focus on the city of Richmond, and I get it. The claim was in the city of Richmond. But strictly speaking, the only material relevant parts of the city of Richmond are the 800 acres that title has been declared on. The other comments about the Land Title Act and the precedent, they are not restricted to the city of Richmond. The media is sort of focused on, well, the city of, oh my goodness, city of Richmond. Look, I don't want to downplay for the poor folks that are directly affected in the 800 acres. And quite frankly, practically speaking, the city of Richmond is wearing this, practically speaking. But the judge did not restrict in any way the comments about the precedent for the entirety of the province to Richmond. That applies to every square inch of the province, according to the judge in Cowichan. And again, I'm not trying to fearmonger. The judge is actually quite clear in the decision on it. So I'll stop there. I know that was a bit verbose. Ran through, I think, the guts of the decision.
So just quickly, so when was the decision? And then, so she's given 18 months from her decision before. So we're roughly just over a year out?
Yeah, we're 4 months and maybe a year out. The province has said it's going to seek a stay, that is like stopping the effect of the decision until an appeal is heard. As far as I know, they have not done anything to give effect to that. And the fact that we're in December and this decision was rendered in August, I will just share with you, I think is appalling. I think we're in an emergency situation. It's my view. I'm not an elected politician. I'm not democratically elected, but as an observer of all this, I don't know how much more serious this can get in a province, let alone British Columbia, without on an emergency basis saying, we need guidance from the British Columbia Court of Appeal on this as quickly as possible. So hopefully they'll file their stay motion soon and get this case rolling and moving.
So did we know kind of what the purpose of this was? Like, what was the Cowichan tribe trying to achieve? Was it like reconciliation? Because it doesn't seem like, going after private land was really on their strategy. Like, have they communicated in their case, like what exactly the outcome they were desired for?
Well, look, I'll say 2 things on that. They have been saying publicly, it's been reported in the media, that they're not after people's private property, to put it colloquially or plainly. They're not after people's private property. Here's the problem with that. And by the way, I'm not suggesting they're trying to be misleading. I mean, they can say it the way they want.
Yeah.
Aboriginal title is the exclusive right to land. Okay? If you ask for Aboriginal title and somebody says, here it is, should you be surprised that you get the land? So, they could have done this other ways. And so they could have said, we want damages. That's compensation for some of your, like we want money for breaching or infringing our title. They could have asked for that. That's what we want.
Like, to play devil's advocate, they probably have asked for that. This has just been the most successful thing so far.
Well, fair enough. But you asked the question, what were they seeking?
Yeah.
They were very articulate and clear. They want title. Look, I agree with you. There's other ways to do this, but the point I'm trying to make is they could have done it differently. It's their right not to. I'm not questioning their right. But to say, well, we don't want people's private property. Well, you asked for title. What did you think you were going to get?
So I guess
Yeah.
the main issue with the outcome is if you have Aboriginal title, you cannot have fee simple, right? Like, is that the conflict?
I would say that's the law currently in Canada. Both fee simple and Aboriginal title. So I've had a few people try to correct me online by saying, well, Tom has said fee simple is an exclusive right to land. There are carve-outs. Of course there are carve-outs. The Crown can expropriate land. It's like Aboriginal title. I got news for everyone. It's not absolute either. The Crown can also justifiably infringe title, by the way. We might want to talk about that because that's interesting. But so when I say they're both exclusive rights, there are caveats on both, okay?
Yeah.
But they're essentially, if I say you've got indefeasible title to your land, that's against the whole world. That's as close to an exclusive right to land as you get. If I say you have Aboriginal title, by definition, the court has said it's not even Crown land anymore. That's the court, the Supreme Court of Canada saying that. So how can you have two exclusive rights to one parcel of land? You can't. It's an obvious point.